to 20-day notice to vacate. So now I'm going to talk about, so just briefly, I'm going to try and hit the tenancy at will. This is not covered by the Residential Landlord and Tenant Act, but it is covered by other landlord-tenant statutes. So Section 2733.10.3 defines the tenant at will as every other person other than the owner of real estate, except for a domestic servant and farm laborer, using or occupying real estate without an agreement, either oral or in writing, shall be deemed a tenant at will. And then 2730-35-30 excludes the tenant at will from being deemed a month-to-month tenant. And 27-35-130 states that all tenants at will shall vacate the premises occupied upon 20 days written notice. So the signs that you may be a tenant at will are that there's no agreement between the landlord and the tenant, oral or written, no rental payments, and the property was obtained with permission from the owner. So the person is not a trespasser. One example from case law would be Bruce v. Durney, which is a 2000s case, where the Court of Appeals held that children, well, really the daughter and her husband, the son-in-law, living on her father's property without paying rent and without a rental agreement could be considered tenants at will. Ultimately, the court determines the classification of the person and whether they are considered to be a tenant at will. So it's really up to the court, but it is important to note that if you are considered to be a tenant at will, you're entitled to that 20-day written notice. Section 2735-130 of the SC Code of Laws requires that that notice be in writing and gives the tenant at least 20 days to vacate the dwelling unit.